So we have a very different setup for this next session. We have a fictitious case scenario where our friends at West Corporation have agreed to sell their company to these nice folks from East Corporation. So everyone's quite pleased with this deal. However, there's now been a very significant breach of the cybersecurity infrastructure after the signing of the agreement, but before the closing. Now, both East Corporation and West Corporation in our scenario are publicly traded U.S. corporations. We're not going to focus on what industry they're in or nuances or responsibilities related to that designation, whether it be HIPAA or other issues. But we think that in a frankly unscripted manner, we can start to draw out what might be the elements of a playbook, of a script that doesn't exist. And we talk about best practice. Well, what if it's not a known practice? And I think this is a situation and a scenario that we've both invented, but maybe taken some inspiration from the real world to look at what are the next steps and challenges and methods to deal with problems, or as we've termed it, a material adverse change between signing the deal and getting it closed, because a lot of stuff can happen. And we're going to try and test out what that stuff may be and have counsel representing each side in this deal scenario. So, Kristen, you want to take it from here, and we'll see what we can find out.
Absolutely, we're excited. I know it's like that post-lunch slump, right? So we're going to get things moving. I'm going to put I'm a forensic accountant by trade, so I serve as a neutral arbitrator. So I'm putting that hat on to keep both parties in good spirits. We're not going to have too many fist fights up here on stage. But imagine, if you will, that you're just a part and another seat at the table, and we're going to go through this. So I have my colleague, David Meadows. He's one of our technology leaders in our forensics practice as well. He's going to be the keeper of this playbook that we have, right? So David, let's show everybody this awesome playbook that we've developed in advance to talk through this breach. What do you guys think? Yeah? Yeah, no, I mean, it's funny, but it's true. There really is not a playbook. We don't have best practices, so we're going to be talking through that and imagining what we do in this hypothetical real-life scenario that there's been a cyber breach. So the first moment, right, the OMG or OM, whatever word you want to choose, that's the moment we're in right now. The holy, oh my goodness, oh my stars. I'm keeping myself censored here since I have kids. So we've got the first 24 hours. So you guys are selling your company. What do we do?
I've just found out. I'm in-house counsel for Company West, Corporation West. And this is my external counsel who's helping me on all matters, the deal and otherwise. And I've just received a call from a colleague saying that there's a breach. Now, I don't even really know what this means. I don't know if this is ransomware. I don't know if this is just a breach that we've identified. So what are some of the questions immediately on the phone? Probably found it out when I was on the phone with him, because I'm always on the phone with him during the deals. What are some of the questions that I should be asking to try to figure out where to go with this? Yeah. What should I do next?
So that's a great question. Look, when in my experience, when you do get that first phone call, the person on the other line generally doesn't know much about it, and that's sort of one of the biggest challenges with navigating where to go from here.
Yeah.
Could be nothing, could be Yahoo. It could be anything in between. And so the question is how do we quickly get our heads around what is the magnitude, what is the significance of this breach? And as much as we're creating a playbook here, for the largest organizations, my assumption is that you probably already have somewhat of a playbook in place, and there should be a playbook for, when the CISO gets a call or when the CISO makes a call to whoever it is in the organization and alerts them of the potential breach, that there's these things that are going to happen very quickly. And we're going to try and do this all real time for you here, and it may not look like whatever plans you've seen or heard of before, but at the end of the day, most of them have some component of all of this that we're going to discuss today. So help me understand, Michele, what's going on in your organization? What are they doing? Do they need outside help? If you're going to retain outside help, maybe you ought to look at having us retain them so that we can preserve privilege since we don't know what's happening yet.
Yep.
Develop a timeline. You know, how quickly will we have good information? I mean, that's also a very important question, right? Mm-hmm. We know very little now. How quickly will we know enough to make some decisions about what we need to disclose, if anything, to anyone, how it impacts the deal? You know, and that's a big issue. And of course, your organization's probably telling you, well, we don't know.
Yep.
We need some time to think about it. We need to come back to you.
Yep.
So
taking that advice and dusting off my playbook, you know, that I was developed through some tabletop exercises that we did too long ago, you know, in our organization as to what to do in a crisis or emergency. I do remember call general counsel. I'm deal counsel. I wish I was general counsel. I'm not general counsel. And call the CIO immediately, as well as bring in the person who's telling me about the breach. So I'm trying to protect this with attorney-client privilege. I'm trying to figure out how to identify and then stop the issue. And then this playbook is saying, I'm calling you again, and I'm working with you to bring in a cybersecurity expert who can help me really figure out what's going on technically.
yeah, and I think that's right. Your playbook probably has sort of a phone tree,
Yep.
or a list of people that are going to get identified right out of the gate as people that should know about the breach. I think the CEO, CFO, CIO are all, you know, good candidates to receive that information. You know, from there, I think your playbook might include possibly calling whoever your IP counsel is if you have regular IP counsel, or you know, maybe it's your corporate firm who's got IP resources, and then transactional counsel if they're different, because I do think that they sort of need to understand what's going on, given that we're between sign and close on this deal.
Yeah,
So.
absolutely, absolutely. So let's dive into that. You've got the first calls that you're making, right?
Right.
Mm-hmm.
How are you considering letting these nice buyers know about this, and talk through those considerations and the timing of communication, if any, to them at this point?
So I don't know what's going on. And so I don't know how this is going to impact, you know, all the different agreements that we have signed up already. I do know that they're going to want to know about it. So how should I best package this up?
Yeah.
What is that call that I should be making, or should I be waiting until I? Yeah.
So, boy, there's a lot of caveats to this, and it sort of depends on how far we are away from our closing. Have all our closing conditions been satisfied, et cetera, or are we months away? But I would say that the worst mistake you can make in a deal like this is to go run to tell the buyer, you know, that we've had this breach, but we can't tell you how significant it is. We don't know what it's going to cost us to remediate it. We don't know what it means for our business, and we don't know what regulators are going to be interested.
Right.
That will set off, you know, a panic, right? And so the difficult part, though, is how do you balance your need for more information and more certainty about the scope of the problem with their need to know it at some point in time in the process, such that it doesn't derail your closing. And that is, and every time I've been through this, that is the big rub, is, you know, how certain do we need to be? How many solutions do we need to have in place? How, you know, to what extent do we have to map out what we think the liability or the risk is before we're comfortable sharing it with the other side? And that's a case-by-case analysis. And it also, as I said, it's impacted by how far away you are from your closing.
Right, absolutely.
So, you know, there's some other things that we should be doing, you know, while we're trying to wait for our technology team and maybe their outside consultants to tell us a little more about the breach. You know, one of the things that we should do, and if it's not in our plan already, we're doing it from scratch, and if it's in our plan, we might be updating it, is we're going to review jurisdiction by jurisdiction whether or not we have any affirmative disclosure obligations associated with that data breach, if it's customer information, for example. So we need to understand that across the board. We also need to understand whether or not we have contractual obligations to disclose, right? Those exist as well.
Okay, let me interrupt you for a minute. Now my compliance team is shouting as well that I've let into the tent, which is something I want to talk to you about too, is who we let into the tent. But one of the things that they're telling me is that some of these state regulations or federal regulations, certainly if we're in U.S., but if we're going abroad, it'd be its own can of worms, are that require very, very timely notices. So this is all really, I don't have luxury here, do I?
Right. No, you don't.
Okay. I should have analyzed this beforehand in the calm, cool of no breach.
That's correct. In the calm, cool, and no breach, you should have identified all of these.
The
before.
calm,
right, that's
cool,
what I
and
make-
it won't happen here, right?
Yeah.
So just make sure.
Meanwhile, your whole IT staff is working around the clock until they can get an answer. I mean, that's really, in reality, what's going on, and they probably have their outside advisors in as well.
Yeah, absolutely.
So we need to understand all of that, and then then there's a question of, okay, let's say we're starting to get more information on the significance of this, and what does that mean both from a securities disclosure perspective and what does it mean from a deal perspective, and those are all very interesting questions that candidly are driven by the magnitude of the problem, timing. Those are two big issues: how much you know, how much you don't know. So
yeah, and we'll jump into assessing that magnitude, and it's constantly evolving as the entire mechanics of the deal are evolving at this point as well.
Yeah. So as you're describing, you touched on the sort of SEC disclosure or insider trading, those obligations, that sort of thing. I have two different populations within my company that know about, and we'll consider this to be a material event, a material transaction, my sale to you, that know about this, that may be under insider trading restrictions right now. Those related to the deal, and now I'm bringing in another group, those related to the possible material, the data breach or whatever it may be.
Yeah.
I have to balance those, coordinate, and keep them all properly blacked out.
It's a good consideration. So as we continue the conversation, and let's bring these kind buyers into the tent now, right? Let's
assume that my
let's
free
fast
martini
forward.
lunch just got interrupted.
Yeah, and
with
let's
the
fast forward
first call
that they've
you can get.
already had their OMG moment, right? And we haven't had any arm wrestling here on stage. So you guys are now under the tent. You know what's going on. You've gotten, your initial call. We don't, depending on a lot of considerations that could have come at some point down the timeline of when the seller actually found out that this breach has occurred. What are your first thoughts when you're picking up the phone, getting that information, and what are the considerations that you guys are thinking about first when you hear about this?
So one just kind of preliminary thing I'm going to want to know right away, is that still ongoing? Is there a risk there's still an ongoing issue? And are you looking at this under privilege? And let's talk about how what you're telling me may or may not be protectable by a common interest type privilege as well. And if we're going, if we're in New York, we may need to say we have anticipated litigation in order for that common interest privilege to extend to the information the seller is sharing with me. So we're going to want to quickly have a conversation about that because there's some consequences. If we are going to say we're treating it that way because litigation's likely, that's going to trigger some obligations for the seller to think about things like litigation holds and other things they may not have done. So it's a not inconsequential conversation about, we absolutely want to know everything. I've called my E&Y specialist who's going to help me look at this, and he's going to talk a little bit about how he'd like to jump in. But I know that whatever I learn, I don't want it to become unprivileged because it's been shared with me, close the deal, and now in the class action lawsuit that is sure to follow, all those conversations become discoverable. So that's going to be first conversation I want to have. Second's going to be, you're right, we went under the tent, and I think we went more than under the tent, right, John?
And I understand that what you're communicating to us is you just don't know at this point, but that's not going to stop my group from asking the questions. A good investigation's a good investigation. Who, what, when, where, why, how, all the things we're going to try to cover, even if the information isn't available. We want to understand, and the buyers that I've worked with want to understand, what you're bringing in. There's a breach or the material event. You're working to stop it. I want to know who you're using to stop it. Are you using your internal IT team to stop it? I want to know how it was identified, who was the person. I want to hear the story, the organic storytelling from whoever identified this breach. And then I'm going to make a decision very quickly as to whether I want you to work on it or not. Because if we are close to the deal being closed and we're planning on absorbing your IT infrastructure into ours anyway, I may have my own people come and address the issue, or a mutually agreed upon third-party contractor that I trust to handle the issue, rather than just, blindly trusting you that you've got it taken care of.
Sure. And that would be a very interesting conversation that I would be having with him about that. A lot of things come to mind. Certainly one of them is, like he suggested, how far away are we from closing? Is there a lot of time? When am I thinking about the likelihood of this impacting closing? And then I'm also kind of going to the antitrust theory of gun jumping and control of another corporation. That's an interesting thought too. I don't want to be headed down that path. So and I'm calling Michael again.
And well, I was going to say, and you're supposed to put a plug-in for Strauss Friedberg, which is Aon's cybersecurity unit. This is where you call Strauss Friedberg and say, we need help.
Yes, for full disclosure, I'm with Aon, and they have the cybersecurity as well.
I assume you guys will also be asking us about, or asking that we limit who we talk to. And as we start to think about the potential impact, not only are we going to want to know what you've all started to analyze as far as reporting obligations, all those sorts of things, we're going to have some conversations about the impact from our perspective. John mentioned one already. Were we thinking about combining systems, combining staff? How is that going to be impacted? And we'll probably talk about that a little bit more. But so there may be some value in this deal that goes beyond the pure value of the seller. But we're absolutely going to want to sit down and start talking with the right kind of people about the possible impacts. So, studies come out every year on the cost of data breach and the impact, and I think the average is something like $250 a person. If we're just talking personally identifiable information, just data records, right? Higher in healthcare, and we can all do the math if we have some idea of who's impacted, but that assumes the only thing that's happening here is there's been disclosure of personally identifiable information. What if somebody's still in the system? What if it's a state-sponsored actor from somewhere else who's engaged in economic espionage, or is lurking and there's going to be ransomware that we don't know about for another 6 to 12 months? There can be other kinds of impact and damage that may flow. And so getting the technical experts, the CISO involved, but also COO who's been thinking about the integration and the synergies from this deal, people who deal with investor relations who start thinking about that possible impact on not just seller reputation, but our reputation and the likely lawsuits that'll flow, the decline in customer confidence that's starting to be, at first sort of Target had a breach, Home Depot had a breach, didn't see much move in the stock value, but that's starting to change a little bit. There starts to be a little bit more sort of customer churn, and breaches are getting more and more attention. I don't know if you know, Equifax is already, FTC is publicly announced, I think. They're investigating, a week and a half after a disclosure. So that's changing. So there's other variables we're going to want to talk about. You guys are probably going to say, only share it with these people, and we're going to say, we need to get our whole team involved in looking at the potential impact before we even look at the arguments under the transaction documents.
Yeah, exactly.
Tying together some thoughts that I shared earlier, I don't think it changes any of what we're hearing here in terms of what the sort of response on the ground is, but so much around the confidence in the buyer and continuing the deal is going to be tied to how we communicate this to the buyer. And I touched on some of it, but I do think that to the extent that you can deliver, a very well ring-fenced analysis of the loss and liability that's likely to befall from the breach, to the extent that you have solutions in place for not only remedying the technology, but dealing with customers, and to the extent that you actually have proposed solutions in terms of how we could account for that in the deal and address those liabilities, I think it goes a long way in the buyer's mind of determining whether or not these are people we can really work with. And yes, we need to do all of the work that's being described here, or somebody get a litigator on the phone now and get me out of the deal, right? And obviously, the desire to own the business and how we performed in the interim, and all of those other things go and come into play. But I do think it's all about being very, very credible with the buyer, and even if you're not giving them all the information they'd really like, making them feel comfortable that you're being transparent with them.
I agree, but I think that does depend on where you are in the
Yep.
cycle. I mentioned I had a client who was selling, and on the morning before the closing, one of their HR people fell for one of those phishing scams from the CEO that says, send me your, and luckily things happened and it just technically didn't go out. But they would have fallen for it, and we would have absolutely had to call the buyer immediately before we knew really what was going on, because you can't move forward at that point with a significant potential breach. So I think we would have lost confidence the other direction. So I think the timing is really key, and the sophistication of the parties. Yeah.
Sure. I think John's comment supported what both of you said, and that the expertise and reliability, the reputation of the consultant that I'm bringing in, or the cyber expert, is absolutely going to help those conversations.
Right.
Definitely.
Yeah. So let's talk about those experts. Let's talk about assessing what we're dealing with, right? We still are, that's evolving as this deal is potentially evolving, but how do you get your hands around assessing this? John, I know you have a lot of experience support, helping buyers in coming in and doing those investigations. And how do you get your hands around this? How can you evaluate, if you can, the magnitude of what's been impacted?
Well, it's finding the right person in the company to talk with, once everything's negotiated, and understanding, like, was it a data loss? Are you losing customer data? Are you losing IP? Are they, I had a client recently who thought that they had a material breach, and it turns out the Russians just hacked into their Linux servers and installed Bitcoin miners on all their servers. No significant impact other than all their cron jobs were destroyed, and they were trying to use their infrastructure for something different. There are other things where I actually saw, it was in Mexico, I worked for a client where they were just crushed that they had this breach, and we went down and we searched and we searched and we searched and we tried to find this breach, and it was a coding error. It was a multiplication error in 2 lines of a ERP table, and it looked like they had lost $1 billion. And the money it was just a math error in the coding. So.
That's comforting.
Look like a hero.
Well, actually, it didn't look like a hero once we.
Comforting, but scary too. That's the kind of math error that's happening. But
yeah, but once we figured it out, they were kind of like, well, "Why are you guys still here?" Like, thanks, appreciate that. But no, I mean, it's not always the worst case scenario. You hear breach, you automatically jump to you've lost all your employee data or all your customer data. There are ransomware attacks that you have backups for. Can they be? Can you put everything back up online? Can you be down a day and fix everything? Or in another case that I'll talk about a little bit later, is your company in big trouble unless you pay this ransom? So due to the nature of attacks and the economic motivations, or if you're a big enough company and it's state-sponsored, if you have a bad actor from China or Russia, Romania, things like that, they're not necessarily stealing your data to make money off it. They just want the intel. They want your IP, threats. If you think back to the earliest days of the open internet and hacking, the biggest country that stole American IP was France. And they had a policy that they would go out and they would steal the newest Whirlpool dishwasher schematics if they could and give it to French industry. And this is going way back. So there were Western threat actors long before there were, what we experience today. So it's really circling back, getting back to understand what is the nature of it, when did you find it, and what do you expect the outcome to be?
well, I would imagine hopefully not, but there could even be some education and learning happening within the organization of where our data actually resides. And which, we hope that's not a learning exercise in this moment, but it could be, right? And I know we've got a handout at the tables talking through some of that data flow and
so the handout
some of those lessons that
that's on your table is for a example client, and you go into a client and they've been breached or they've been hacked, and they can hand you, during the deal, they can hand you a network map. They can hand you a Visio map and say, this is where our perimeter is, this is where our DMZ are, this is where our servers is, these are where our firewalls are, this is what someone from the outside can reach, and this is how we talk to each other internally. What may need to happen after a breach is the seller may need to conduct or build another map to show the data, where your data actually lives. And these are SQL servers and ERP servers, and understand that once the bad actor's in your network, where can they jump? Who are the data owners? Which information can be touched? So this may be another completely different map set that would need to be given in disclosure from the seller to the buyer in the event of something else happening like this that's over and above your standard network map and standard what comes in packages.
So can I just highlight one other thing that I would ask in that first call would be, is there cyber insurance? Is there insurance that's going to help here? And then the other thing I'd be thinking about, and I know it's come up a few times, and wearing your not actor hat, I'd love to hear thoughts about impact on rep and warranty insurance, because now this is now a known issue.
Yeah.
So if I have buy-side rep and warranty insurance, I'm going to start thinking about, if that's what I was relying on, and maybe I took a different approach on the reps and warranties and how we were negotiating the transaction documents, this may have a significant impact that I've learned about this. And I don't know if
Sure.
you guys have seen that, wearing your Aon hat.
Yeah, let's jump into the dollars.
Well, let me stick with my West Corporation hat just for a minute.
Yeah.
I'll blend them together. I can't help it. But so cyber insurance and some of the different types of data breaches or events that we could be incurring that you were describing are absolutely going to be informing our next action steps as well. And the size of this will inform it as well. So there are a million different types of cyber insurance. And when we think about where the actual dollar loss is related to a cyber event, it may, for instance, take ransom, $300. Ransom, you get your data back or something, or a couple, 50,000, whatever small-ish compared to material transaction dollar amount you want to throw in there. Sure, there is cyber insurance that covers that extortion amount, but there's also cyber insurance which is going to be covering all of the other aspects, and hopefully I have a complete coverage, and the real dollar value that I may be experiencing is going to be underneath the all the outreach to my clients, all the resulting lawsuits. That's where the real materiality of this event is. It's not the payment to the ransomware. So what I need to be doing is seeing under these policies if they are directing me to have coverage under them to be acting in a certain way. For instance, they may say, we will not cover you if you don't get the FBI or the federal government's approval, or if not explicit approval, at least their agreement not to be enforcing you, to be paying that ransomware. That may be an actual step in your coverage that you need to be following if you're going to be getting it. Or there are also, as we're talking about, as Michael said, all the different vendor and state law regulations and other issues related to a data breach. There are also going to be steps in your coverage as to when you notify them, how you notify them, and that's just going to be absolutely important. And they are going to want, depending on where we are in the closing point of view, they're going to want to make sure that who's going to get my cyber insurance, if there's a change of control provision, if they're going to have access to that, that sort of thing, pursuant to this deal, or if they're going to be relying on, if we're talking material transaction, then it's almost impossible for their own cyber insurance to be covering this prior act event. So there are lots of different pieces that we need to be driving here.
So it sounds like one of your first calls, maybe
Yep.
after you get the initial group, is to your risk manager. And
Absolutely.
Your risk manager is going to take a look at, number one, do you have a cyber standalone policy? But
Yep.
you also need to look and see whether or not your E&O or your general commercial liability policies offer any protection. And then, as Michele articulated so well, there are steps, whether it be notices or other actions that you need to take, and those all need to be identified. And hopefully this is all in that plan that you built ahead of time, but if not, we'll be constructing it
We're
real
making
time.
it right now.
Yeah. I would want, taking my West Corporation hat off, I would want them to be making sure I am, before closing, am actually notifying my carriers, right, and following those events.
Let's talk about other dollar impacts here. So we've gotten past communicating this, and we're still, maybe we've got our hands around what the total impact is. Maybe it is still evolving. But what impacts are both of you considering as both seller and buyer around deal financing? Any other contractual considerations that we should be thinking of? Conditions that you might be putting on closing? Let's talk through some of those.
So one of the things that I've experienced is a breach following or contemporaneous with a deal closing is now the third-party contracts. Still, Target is very old news, but companies are still being affected by breaches through third-party vendors and contractors. And then it becomes an issue. The first thing I'm going to do when I take over your company is I'm going to fire that organization because they were the point of the leak. And then what is the, what's my liability is, if you have a 5-year agreement with them and I'm going to fire them the day I walk in the door because they caused a breach. And so that's also a consideration that I've seen companies really have to wrestle with going in.
So I was going to say that I suspect that Michele had a conversation with her CEO, and the first question he's going to ask us, are we still closing? Right, and that
Same
gets,
here.
and that gets to the loaded question of the title of this presentation, which I think had the term MAC in it. And this is where I'm going to actually ask for some audience and participation. But somebody please tell me what a unicorn, a leprechaun, and a Mac all have in common.
Oh, boy.
Lots of people believe they exist, but nobody's actually seen one. So, if you take a look at the news in the last 6 months, you probably paid attention to the Verizon-Yahoo deal. So Yahoo announced 2 separate customer information breaches in a 6-month period, all between signing and closing in that deal. The first one was 500 million accounts, and the second one was 1 billion accounts. That deal closed in June of this year. A MAC is a very, very high standard. So while I don't like to give advice to my clients that says this is 100% for sure going to close, I think you have to be able to tell your client that there is leverage in this depending on the size of the risk and the loss for the buyer, but it will be very difficult for them to walk away completely from the deal. That doesn't mean it isn't going to be painful for you, though, and clearly it was painful for Yahoo. They ended up lowering their purchase price, and there was a delay in the closing, and it's not without its cost. But in terms of absolute closing, it's pretty hard to find a MAC.
But I think that is the key. There are not many, if any, situations where people have been able to defend triggering that material adverse event, condition to close, and backing out. But it is absolutely something that creates a basis for negotiation. And for one reason, even with the standard being relatively heavily weighted against the buyer, it has to be of a long duration, it's got to be significant, but it's a fact test. And so who wants to say, yeah, we're going to take a risk and go fight about this in court? It's not going to be something that goes away on a motion to dismiss.
I don't think her CEO wants to be the first
Exactly.
company in history to
Nor does
actually
mine.
identify what a MAC is.
Nor does
they
mine.
lost in litigation.
So it does become the framework for a conversation about price. So Yahoo, Verizon affected price by, I think, 7%, but also some other terms. So in that situation, there was some allocation of costs of dealing with the incident, including Yahoo picking up, I think, 100% of the costs of defending shareholder litigation. One question I was mentioning to John today, I don't know if that included shareholder litigation against Verizon, because there ultimately were lawsuits against Verizon and its board for sort of aiding and abetting this whole situation by the very act of negotiating a lower price being argued to be sort of an unjust enrichment or aiding and abetting the issues. So like I said, litigation will follow, and likely it's going to impact both companies. So I think in addition to thinking about the price, I'm going to be wanting to reopen some of those allocations of responsibility, whether for discrete costs. I'm also going to be very interested in the duration of reps and warranties and the duration of any kind of holdbacks and escrows aren't going to be as likely in this public to public probably, but we don't know what the costs of a breach are for a long time. Especially, again, if you're in a regulated area like healthcare, you could report a breach to OCR and it's 5 to 6 years before you've negotiated the penalties. So 18-month escrow that might be typical, in your E&Y studies about how long people are setting money aside, it's not going to be helpful in these kinds of situations. So those variables are all going to come into play, I think, in our conversation.
Yeah.
When we're having those calls and I'm hearing the price dropping, getting very uncomfortable as I'm in these negotiations. And the other thing I'm also hearing that she alluded to is that perhaps there's a special indemnity or something like that that's worked into play. Well, then we get back to John's conversation about control. Then we get a situation where I am financially, my price is dropped, I'm financially responsible for it. Is he controlling it? Who's controlling it post-closing? Who's experts? Who's doing that? What access do I have to the information to this company that is now theirs, and I'm a third party? So there's a lot to.
And maybe we should be clear. In this fact pattern, we assumed that West was public. It wasn't clear whether or not we were selling a business unit or ourselves. If we're selling ourselves, clearly, we're not going to have an indemnity. If we're selling a business unit, then I think all of the questions raised about, what are the bases for claims that East might make against us, and that would, they'd be looking at breaches of reps and warranties, breaches of covenants. Our duty to update schedules comes into play. We also have to worry about whether or not we have a notification obligation for you all. Obviously, we talked about the closing conditions, the scope of the indemnity obligation, and then as Michele said, how is litigation going to be handled? Yeah. So those are all more common to the private context rather than the public context. But, either way is. Yeah.
And I'm going to be digging into that document for all those reps and warranties, and I'm going to look past the section that's either covering, IT or privacy, and think about, is this a failure to protect trade secrets? Has IP been defined broadly enough to cover third-party confidential information? And maybe this PII is that. So I'm going to be digging through that document to think about all the ways that this may have come into play and create a situation that makes you uncomfortable.
And to be clear, we never gave you that undisclosed liabilities.
And I wonder, I asked earlier in the session how many people were seeing more diligence. How many of you are seeing issues around adequacy of cybersecurity controls, training, policies, procedures, specific reps around that? Is that, because I still see that only about half the time on, especially again on smaller deals. I think people are still kind of burying some of that in the IP section. Maybe they're covering privacy, but they're not getting into security. And similarly, how many of you are doing diligence where you're bringing in a Strauss or somebody, an E&Y, to do a deeper technical diligence beyond just, asking if you have a program?
A couple more hands.
Yeah. More? Yeah.
I would guess people would respond. It sort of depends on the target.
Yes, for sure. Yeah.
No, but it's an interesting point, and we're talking through this in the context that we've signed, but we haven't actually closed yet. But how does this conversation change if this cyber breach happens before we've signed, and there is still that ability to negotiate or walk away? I think that's a lot more common. Like I was just perusing, we put out twice a year a survey of thousands of C-suites and corporate acquirers and kind of pull those data points together, a capital confidence barometer. And as you'd expect, the question of what has caused you to walk away from a deal in the last 12 months? Well, as everyone would expect, that something that's been uncovered during due diligence is the highest percentage, 45% or something, 43%, something like that. The next highest was, I have concerns about the cybersecurity, which is certainly not something we would have seen out of that survey years ago, or even just half a year ago.
Your March publication also had an article that quoted a survey, and CEOs were asked, would you consider acquiring a company that had a cyber breach? And something like 75% either said no, or only if we got a really good deal.
Yeah. Right. Only if that price is way down, right? William?
Well, actually, this is not William. I'm the
okay.
I'm the due diligence guy at East Corporation, and John, I'm calling you because although we've never met, I heard you have access to all of West Corp's systems. There were a few things I couldn't figure out in diligence. Could you just check those out for me?
Well, if I have access to all their systems, I'm going to put an endpoint on their systems, and we're going to try to discover which computers are talking offline. It's a very useful tool and ability to see if they're talking back to IP blocks to known C2 servers across the world and things like that. So at this point, we see that they have a few machines talking out of line. They're infected with something. We don't know, the nature of whether it's an emotet loader, it's a dropper, it's a banking Trojan. We don't know anything else like that. We just see that there's TCP packets flowing to someplace it shouldn't be. So in that case, we're going to want to have the agreed third party come in, do a full forensic investigation of those computers.
But Ann, you don't mind if we use this opportunity to shop around through their information, right? Isn't that fine?
Yeah, exactly. Back to our concerns about the liability we may have in what we're doing, whether, especially if the deal doesn't end up closing, setting aside the antitrust issues. So we've got to be thinking about that. And, the insider trading issue that Michele raised, if I'm public, I've got the same, whether I'm not in public, but I've got the same kind of issues as it relates to their stock, but I may have issues with my own depending on how this is affecting the deal. So, yeah, good cautionary note.
There's an interesting point that I came across in doing some background research for the presentation today, and it was around Equifax. And apparently, the senior leadership of Equifax sold 2 to 3 days after the breach was discovered. And so they were clearly not blacked out. We don't know all the facts. It could well be that, as I suggested up front, they might have known of a breach but had no sense for the materiality of that breach. But the problem you have in every instance is that it will be evaluated in hindsight with the benefit of all that has happened since then. So the decision not to black out the insiders in that, particularly for that business, is an interesting one because it's all about consumer data.
Right.
And it's certainly a good lesson for all of the C-suiters in this room and the legal counsel that are advising the C-suiters. Conservatism is probably in order when this first hits.
There's that, we may not have the playbook for this exactly, but there are analogies to the playbook when you're acquiring a target that has a drug sitting at the FDA waiting for approval, and you find out it's not going to get the approval midstream. All those same scenarios around what to do with that information are going to play out here. Yeah.
Yeah. So let's move this forward. We're going to assume we're going to close, right? Let's talk through, again, on both sides of the table or both tables, integration considerations and what we're thinking about after we close, and if there's any lessons that we're going to learn through this process that we will apply on future deals. Hopefully not every deal has a cyber breach, but for others in the room that might be facing that.
Well, hopefully the combined company now has a playbook. At bare minimum.
And I've run across companies that have very specific, dollar amount playbooks. My company is worth so many billions of dollars. I'm buying a very small market cap company, and I'm going to take it as it comes. And whatever comes along with it, if it's under this threshold in the first 90 days, then I will assess its cyber position, its maturity, any issues it has. And I'll just take that because the value of the company that's being acquired is worth more to me than worrying about the remediation. And when I'm acquiring this many companies over the course of a year, I've seen a couple very large acquirers not even really concern themselves with it. If the deal is small enough that it just goes through.
So I would say from an integration perspective, I'm going to need to revisit staffing plans, and there may be people I need to make sure I have access to that I didn't intend to incentivize to stay with me. I may have thought and agreed that some of the board members from the seller were going to sit on my board for a while, and they may be facing litigation in their role as fiduciaries of the seller. I may be dealing with that dynamic in a different way. I may have not only just the, not the cost savings of combining IT systems, I may now have to operate with 2 different ERP systems, for instance, or 2 different CRM systems, 2 different direct-facing marketing databases. So not only have I not gotten the benefit, I now am trying to deal with systems that can't talk to each other because I'm worried that there's still a vulnerability. So that's going to increase my costs and just make life miserable for a while. And if it's a data face, if it's consumer data, and I was thinking I'm going to be reaching out to all those customers and saying, hey, welcome to the Ann Ladd family. Here's your nice updated privacy statement. I might use your data a little bit more broadly than they used to. Wow, are people going to be worried about what I'm doing after this happens? So again, thinking through some of those benefits you saw in the combination and how they might be impacted by this is going to be part of what I'm going to look at, and it's going to change my integration.
Those are great points. The synergies that drove the deal in the first place that you're looking at, and how those are impacted in integration with this new dynamic is just huge.
Yeah.
Absolutely. Well, what questions do we have in the room? I know we've got just a few more minutes, but it's been a fun conversation so far, yeah.
Got a quick comment. So my name is Richard Franco. I'm the integration lead. Thank you. My name is Richie DeFranco. I'm the integration lead for a company called Oath, which is the parent of AOL and Yahoo. And so this conversation is like kind of making me twitch. So I think like you totally nailed it. I think so. I focus obviously on the integration side, but it was like more than a curveball that was thrown to us. And now there's an IT security clearing process that's in the middle of everything that we do, and it has kind of crippled the integration that we had planned on doing. And so I think one of the things that we tried to assess also was the impact to the Yahoo brand, and how as we enter into new markets or we try to do more things with Yahoo, what do the consumers think of the brand in general and how that's going to impact our business. And so, but I think all this other stuff, you completely nailed it, and it's been our life for the past year. So.
Yeah, it's a great
Well,
point.
thank
Thanks
you
for
for your
sharing.
comments.
Stay strong.
Yeah. Is there another comment right behind you at the next table? Did I see another hand right over there? Am I making it up? All right.
Move back.
Okay.
Would you mind talking about a circumstance where the buyer backs out of the deal? I mean, say if somebody was looking to buy Equifax, they probably would want to pull out. And just understanding, I don't know, that process and break fees, who pays who, what, I assume that would be in the legal documentation already, but it would be helpful to understand that because clearly the MAC's in there for a reason, and when you're negotiating a MAC, you need to consider the possibility that it comes into effect.
So, we had 2 scenarios we discussed, right? Both the public company acquisition and a private company acquisition from a public company. They're going to probably be slightly different scenarios. My assumption in the private context is that there's probably not going to be a break fee. So it's a question of whether or not the closing conditions are satisfied at closing. If they are, the buyer will be obligated to close. If they're not, then the buyer can walk away. That gets to the point that we talked about earlier, which is essentially what is a MAC? That's commonly what is included within the closing conditions as a basis for the buyer not to have to complete its obligation, again, in a private context. I think the most likely scenario is, and maybe we'll ask East to chime in, but East is probably going to call West, or their counsel is going to call West and say, we're not closing. And that's going to send panic throughout. And then the first response is, well, look, I haven't seen a unicorn, I haven't seen a leprechaun, and there is no such thing as a MAC. So let's be real. What do you really want? And I think that's where the dynamic around additional time to let E&Y do their diligence occurs. There's a price adjustment. There's, it sort of depends on the facts and circumstances, but the lever that's being pulled is the MAC. The problem is they can't really go through with it. All they can do is sort of threaten us with it. And from our perspective, The challenge is we don't want our deal hung up in court for the next 6 months. We want to close next week or a month from now, whatever it may be. So we're going to work with them to some extent, right? We're going to find ways to get the deal done. I think we'll probably have to be very open and acknowledge that maybe there was some damage done to the business from the time the deal was signed, and that the buyer didn't account for that, and it might be fundamental to the deal itself, and they might need compensation for that to get them over the hump. So I don't know if you wanted to chime in on that.
Just maybe take a step back. The test in U.S. law is going to be whether there was an unknown, unforeseeable event that's going to have a significant impact for more than months, a year's kind of impact. So, 3%, 5%, 10%, 20% downtick in earnings or valuations for a few months is probably not going to be enough to justify saying there's a material adverse event, condition to close can't be met, we're walking away. There have been a couple cases, not in that exact context, but in the breakup fee context, that have looked at that and said, well, maybe it would be impossible. This has been such a significant change, you can't close. But so far, I'll just say so far in the data breach world, just data breach, set aside loss of trade secrets, something more fundamental. In the data breach side, people haven't experienced that long-term impact in a way that I think is going to be viewed as that significant.
Yeah.
If it's IP that's lost, if trade secrets are shot or things like that, I think that's a stronger case.
One thing we should say, though, is we're assuming that we actually got a MAC bring down across the board in this deal, which may or may not be the case. So a MAC closing condition is a generalized closing condition that goes to some of the things Ann's describing. It's, what is the long-term value of the asset? Has it been harmed in a material way? But it's possible that in the bring down of the reps and warranties, particularly if you're buying, let's say, a target that is a technology business that has lots of customer data, whatever it may be, you may have actually negotiated a different closing standard specific to those reps. And maybe it's just materiality. And that might give you a pretty good lever to pull to just walk away from the deal. In the public context, it's a little bit different. You would have a failure to satisfy, I guess, a rep or warranty. You would have a cure period. And if, for whatever reason, it still wasn't cured, there would be a termination right on the part of the buyer. The last time I looked closely at this, I don't believe termination fees are ordinarily associated with that unless it was intentional. So.
Somebody have a comment in the back on that?
Oh, we both pointed it.
Just a question about, it seems as though some of the breaches have become virtually ubiquitous. We hear about data breaches all the time. I just think 5 years ago, if I had heard about a data breach, I would consider that in the category of a MAC. So what exactly would be that material adverse change? What would qualify? I mean, what happened with Equifax seems so significant in terms of impact. Is the public, I guess, naive about how that impacts them personally? Is it not, what would be that?
Yeah.
Well, so I'll just say, and maybe the Equifax situation's going to be interesting to watch play out. But when you think about the kinds of claims that get made against a company when it's had a data breach, so far, the sort of private causes of action by individual people whose credit card number was taken are either not upheld because they don't have standing, or the awards and settlements are still not that large. We think about it as a significant component of earnings. And until recently, there wasn't a lot of evidence of it affecting consumers, but I think because we have become sort of inured. So I think it's the other kinds of costs or the other kinds of lingering concerns about what it means about the stability of the company that I would find more likely to lead to that. I don't know.
Okay. I need to know my company, and I need to know the data that my company has, and I need, outside of this strategic transaction context, I need to be living data privacy. And so I need to have this playbook. We do have this playbook, and that's an integral part of understanding all the different state and federal regs that are applicable for the particular type of data that I have. Now, just to show you some extremes, in some situations, if data is just out of my control, but is still encrypted, that may not technically be a breach if it's certain types of data in certain types of states. Or if it's just accessible, it certainly may be a breach. So there are all sorts of different, very specific ways that regulation can apply to this that would then go to the materiality of it. So you got to know your company.
I was going to offer up a hypothetical, and it's only because I'm sure everyone in this room has thought about this at one point or another. Our whole financial lives are a series of zeros and ones somewhere out there in the ether. Like if you woke up tomorrow morning and your Merrill Lynch account was zeroed out, it seems to me like if there were enough customers that had that happen, I got to believe you could find a Mac in there somewhere, right? But I think it's difficult because there's statutory fines that are available for data breaches, but it's a question of like what gets stolen and what's done with it and what's the actual damage that occurs as a result of it that is sort of the big unknown. And it's quite frankly, and maybe this is an interesting topic for you to take up, if not now, some other presentations, sort of how does that impact the availability of cyber insurance products, because who knows in a lot of cases. I mean, the data is getting better, but it's so dependent on what data they're getting and what data they got from other people and whether or not they'll be able to combine it and do actual harm.
Yeah, I mean, that key word is materiality. As the nerdy accountant, I'm like, it's the materiality and how it's defined. Other questions? I know we're probably at our,
Just about, I'm afraid we're just about out of time.
crane us
We're
off the
going over a
stage.
little bit.